and courage. And these boys spent 2.5 years here, working hard and doing what they were supposed to. The shooter was here for 6 weeks, and I think if Colin was standing here today, I promise you he would not say, "I wish I had a gun that night so I could have fought back." He would have said to Stephen Jones, you're here for 6 weeks. This is where we come to learn, to grow, to become men, to figure life out. We don't solve our problems with pulling out a gun. It's not an option. Colin's last words that night were, "Why did you bring a gun here?" And I think he would still say the same because it was so foreign to him. So I ask that you, just like the others, would protect them this time and protect this community, their school that they loved. Thank you.
Thank you, Ms. Taylor. Okay.
Thank you, Your Honor. Your Honor, I'm aware that the court is familiar with the facts of the case up until this stage, and I don't want to spend a lot of time talking about the facts, except for to say that the state does take exception with the factual representation with regards to these circumstances presented by the defense. And I think it's important to note that part of what the defense does is essentially ignore the fact that the defendant traveled from his vehicle more than 90 feet back to the location where he shot Colin. He went from his vehicle where he collected a gun, went back across the parking lot, and shot 4 people. There wasn't even a physical confrontation going on at the time. He walked across the parking lot and shot 4 people. He killed one of them. He almost killed another. The other 2 are lucky to have their lives. And the defense ignores that traversing of distance between the vehicle and the car. And I point out specifically, this is the defense indication of the facts. Stephen reached his car and obtained his pistol from the glove box. Unsure of his exact surroundings because his glasses had been knocked off his face, Stephen announced that he had a gun and yelled at subjects to stop. Unbeknownst to Stephen, the subjects had discontinued their pursuit of him, but 2 of them quickly started running back towards him after he shouted commands at them. As Stephen held his pistol at the low ready position and again yelled for them to stop, alleged victims Colin Breaux and Nicholas Peering stated that they were going to kill Stephen and charged towards him. And I would point out a few things there. The first is, it certainly is written and suggests that this occurred just outside of the defendant's car, which is provably untrue. Second, it suggests that both Nicholas Peering, it doesn't suggest, it says that Nicholas Peering and Colin Breaux ran towards the defendant, and then he warned them again, and they continued to run towards him, which is also provably untrue. And I would suggest, Judge, that the reason that I'm pointing all this out to you is because the defense is indicating that the defendant wants to clear his name and that really this is a self-defense case. I would suggest, Judge, that the facts for the charges and the indictment against the defendant are extremely strong. There's a whole bunch of weaknesses to the self-defense argument, perhaps the best being that the defendant left the confrontation and was quite a distance away from it when he armed himself and then recreated, with regards to him, a new confrontation. When the defendant leveled his gun at the other individuals who were out there that night, that's him creating a new confrontation, introducing into that second confrontation deadly force which didn't exist prior. Clearly, self-defense isn't going to cover this situation. The other evidence that the defendant gathered his gun, walked across the parking lot, and shot 4 people is very strong. And therefore, the strength of the evidence against the defendant is strong. The likelihood of the success of his defense is low. And the potential penalty that the defendant faces is extraordinary, as the court is aware. With that strength of evidence against the defendant, and with that potential penalty that he faces, there's an inherent flight risk, a strong flight risk. Of course, that's only part of the concern. A major concern in a case like this, where somebody introduced extreme deadly force into what was, at best, a fist fight, is that this person is dangerous. The provable information in this case, the information that's on the table, is that under circumstances that strain credibility to argue that deadly force was even something that should have been contemplated, this person armed himself and shot 4 young men. He's clearly dangerous. And he represents that danger to the community, whether he's on pretrial services, whether he's on electronic monitoring, unless there is somebody standing next to him to watch his everything that he does. That dangerousness continues to exist, and it's expressed by the victims, who are obviously terribly saddened and tortured by what has happened, what the defendant did to them. And I would argue to the court that it's also a representation of the senses of the community on the subject of whether or not the defendant represents a danger should he be released. I would argue that that danger is very strong, and it's felt, and it's observed by the victims and members of the community.
How about the assuring the appearance of the accused?
Well, Judge, like I said, the primary argument on that is the strength of the case and the potential penalty against the defendant.
Then are you arguing that he shouldn't be bailable?
I'm arguing that I'm arguing at this time the conditions of release should not be altered.
Okay, I have assuring the appearance of the accused. This is the purpose of bail, assuring the presence of the accused. I think it's interesting that that's the first thing that's mentioned in our Constitution and in the criminal rules. That's the first thing that's mentioned. I think that's what they're directing judges to look at. What is going to assure his presence? You've offered me, and I'm trying to figure out. I'm trying to listen. I mean, these are serious charges, but what I haven't heard is, and I understand the weight of the emotions in this courtroom is palpable and significant. But I know you and Mr. Barker and Mr. Davidson and Mr. McCown and Mr. Rabb, for that part, and Mr. Diesel do not take the presumption of innocence that is upon Mr. Jones to be a legal fiction or a trite nicety in our law. And I don't hear anyone arguing about the presumption of innocence. And looking at that, all I hear is presume him guilty. And is that what I should be looking at? Presume him guilty.
Judge, I certainly never suggested that the presumption of innocence is a trite nicety.
And I know you didn't, because I said you believe in it.
And the state certainly never suggested that there should be a presumption of guilt. But what the state is suggesting is that, as indicated by the statute, the factors that are taken into account are the strength of the case. And the state is presenting to the court the extraordinary potential penalty that should the defendant be convicted, and arguing that because of the strength of the evidence, the likelihood of conviction is strong, that the impact of that information on the defendant is going to be that if he presents himself for trial, he may never leave outside of custody. And that fact has an impact on somebody who's deciding whether or not they're going to present themselves for trial.
You're aware of the case law that says the strength of the evidence is actually one of the least factors that a court should consider, correct?
I am aware of that, Judge, but only in the respect that the court is thinking of it, which is whether or not he's probably guilty. But I'm suggesting that that piece of information becomes important when you consider the impact that the potential penalty is going to have on somebody who's deciding whether or not to present themselves for trial. If it was a very weak case, or if the defendant's self-defense argument were strong, maybe more stock or more weight could be placed into the idea that he does want to clear his name.
How about 24-hour real-time GPS monitoring? Not summary now, because I know that we used to at one time had summary, but 24-hour real-time GPS monitoring.
The state still believes that the defendant represents a danger to the community.
Okay, all right. Would that address your issue regarding the flight risk?
Judge, I would suggest that technology like that, I'm not saying that there's evidence to suggest that this is going to happen, but just in response to the judge's question, can technology be beaten? Of course it can. And so,
what I hear is you're inviting me to do an awful lot of speculating. He may flee. He's got serious charges, so he may flee. So he may disable the bracelet. So he may get access to weapons, even though I could order that his home be subject to 24-hour search. He may go down to downtown Phoenix, at 3 a.m. in the morning and pick up some 38 or Saturday night special. He may do this. There's nothing in the rules or the statute or the Constitution that allows me to speculate about that.
I think that
and I guess the thing about it is, Mr. Shea, is really what I am left with is, what is it that you have? You have the charges. You have the investigation. Do you have anything that shows that he is? Do you have any evidence, any suggestion, other than a speculation based upon the charges? Because if I just go by the charges, nobody gets out. A lot of cases, nobody gets out. Because anybody charged with an offense for which they even could go to prison would represent a flight risk.
I think that argument exists. I think that
in the context of our Constitution, in the context of the presumption of innocence.
Well, Judge, let me take it from the other perspective then.
Okay.
There's nothing that the state is offering here that is different than what is offered in many, many bail arguments in this courtroom.
Not your strongest argument, because I've released a lot of people who the community may have thought presented a danger, and I released them to pretrial services under some extremely onerous conditions, the least onerous, and they appeared for trial. I'm thinking of one young woman, I'm not going to get into specifics of it, that was facing mandatory prison. Same as Mr. Jones. Serious offenses. Very serious offenses.
The only reason that I'm suggesting that, Judge, is because whatever the court is indicating requires speculation is in fact just the weighing of the factors that the court is instructed to weigh in making these determinations and see what conclusion the judge is pushed in. And it's clear to me, Judge. It's not wise for me to try to go toe-to-toe with you on these issues. You're much more familiar with the posture of a jurist on a question like this. But the state's position is that the defendant does, based on the evidence in this case, represent a danger to the community. It's exhibited in the evidence of this case. It's exhibited in the inferences that can be drawn about his decision-making process when he elected to engage in this series of events, series of decisions that wound up with a young man dead and 3 others shot. His dangerousness is right there. In terms of his likelihood of flight, I don't know him personally, and there isn't a psychological evaluation of him to which I can reference. But I can offer that...
There is our pretrial services report, right? Shows him at a very low risk, and to reoffend and a very low risk of failing to appear. In fact, the lowest risk on a nationwide assessment that has been validated and shown repeatedly to be accurate. People do show up charged with first-degree murder. They do show up for trial.
It's true. Also, some people don't. And I would point out that with regards to that evaluation, not a single question is asked of the defendant in order to draw that conclusion. So the state's position is that he does represent a danger. The state's position is that spending decades in prison would be a significant impact on somebody's decision on whether or not to appear. For what it's worth, the weight of the evidence is strong, and the state believes that, the bond is based on this idea that if somebody has to actually post the money, then that encourages them to make sure that this person gets to trial. I mean, that's the whole idea behind somebody having to post money. When the motivation to flee is so significant, the bond must be significant in order to counterweigh that.
Well, here's the question that I have then. What do you know? Were you present when the bond was set? I think it was set out at Justice Court. Okay. So, what was the bond that was asked for?
The state moved for the defendant to be held without bond, and if I may.
Asked that he be held no bond based on the offenses that are non-bailable, as the court referenced. And then I said, because I believe that the presumption was great, evidence was great at that time, and it still is, that he should be held without bond. And then I asked that he be held, if a bond was imposed, something in excess of $1 million, and the justice of the peace, I can't remember who it was at the time, set $2 million cash only. That was my recollection.
Okay. So it brings up the question then that at one point the state believed that if Mr. Jones was capable of posting a $1,001 bond, that would be enough to assure his presence and the safety of the community.
Well, I can't dispute that summary. Of course, I think that the safety issues exist, whether it posts a bond or not. But.
Sure, but here's the problem. A bond is not supposed to be a punishment. It's not supposed to be a pre-jury verdict punishment, right?
I agree with that, Judge. I don't think that anybody's suggesting the imposition of bond for those purposes.
So in the prosecution's opinion, a $1,001 bond was sufficient to assure his presence in court, the safety of the victims and their concerns, and to address any concerns about flight risk.
I don't dispute that.
You don't get to tag team, Mr. Barker.
Well, I'm just going to say, because I was the one that asked for it.
Okay.
So I represented the state in that instance. I did not agree with that, Judge. In fact, I asked for no bond. I asked for non-bailable. It was a non-bailable offense in my opinion. And by the way, that is just based on a charge, as the court was asking about. We just hold people no bond based on a charge. So
is that the defendant has since been indicted by a grand jury to first-degree murder and 6 counts of aggravated assault, which are of a dangerous nature and each carry their own mandatory prison sentence.
Oh yeah, I mean, if Mr. Jones is convicted of all of them, I mean, basically it's a life sentence. I understand that, but in terms of what I'm being asked to do to review conditions of release, I can take into, you're absolutely right, I can take into the weight of the evidence. I can take into consideration the danger to the community that Mr. Jones may present. I have to take in a whole bunch of other factors that are listed in 3967, which, for the record, I want to make it clear I have considered. Some of them are not applicable to the determination in this, in this case. But I guess what I'm getting at is, the state asks for a bond. And in asking for the bond, I mean, on a charge like this, the state has the opportunity, and they have the right, to present a case at a conditions release hearing and say, I'm sorry, we don't want a bond here. We're going to show that the proof is evident, presumption great, that this should be a non-bailable offense. And the state has not done that. It's not asked for a non-bailable offense hearing.
Well, just to be clear, we did ask for it initially.
Well, you asked for a no bond, and that's normally what's done at the time. But the Constitution and the case law actually is something different than just simply going to a JP and saying no bond, because at some point in time you're challenged.
Well, we would have had to present
correct
evidence.
Correct.
But we were prepared to do that when we made that request. I think there's a time limit with which we would have to have that hearing.
And that wasn't done.
Well, we asked for it. Cash bond was set instead.
I understand, but you could have asked. You could have said, Judge, we want a hearing on this because we think this is a non-bailable offense. You could have asked for that hearing, correct?
I believe so. I would have to go back and look at the specific procedure on the subject. However, $2 million was imposed, and $2 million appears to be sufficient to satisfy the state's concerns, the safety of the community, appearance for trial.
What's the difference between $1 million and $1 cash only and $2 million?
I guess that's something for the court to consider.
Okay, and that's the whole, that's the issue that I have to struggle with on this. Is we're asked, as judges to basically take risk. I mean, we're in the business of risk management. That's what we do. And so we're putting a number on the factors of 133967, Article 2, Section 22, Rule 6, I think, is so on and so forth, and we're going. This is all of 133967. All of those statutes and rules are met by a number, and that's the issue that I have. Is it just a number, or are there other aspects that I should hear about that are not necessarily present? And I do. I have this. Now, you're right. They don't ask any questions on it. It doesn't necessarily. It may go to the weight that I give it, and I've certainly, not been shy about my views on certain pretrial services assessments. But I cannot state, and it's been drilled into us, and we're going to have it again repeatedly by judges and by those involved, and former judges, retired judges that I respect, that this is validated.
I understand
and it has shown that you can allow persons charged with the most serious offenses, and under certain circumstances, you can release them.
I suggest, Judge, though, that as the court is pointing out, deciding what is the appropriate bond is something that is not can't be reduced to a question of weights and measures and numbers and no questions to the defendant. It's still always something that's left to the discretion of the court, and I suggest there's a reason for that.
All right. I appreciate it, Mr. Chairman.
Thank you, Judge.
Thank you for your argument. Briefly, Mr. McDowell.
A moment ago, you just asked what's the difference between 2 million and 1 million. Of course, it depends on who you're asking. I would assume for just about anyone in this room, there is no difference. For probably just about anyone in this room, there's probably not much of a difference between 2 million, 1 million, and 100,000.
Well, Mr. Count, the other aspect about it is that a bail is considered not only, the bail is set not only to consider the return of the person to, the assurance that the person will appear for trial, but it also calculates into it the safety to the community.
I understand Your Honor's concerns with that, but as we discussed earlier, there are things that Your Honor can do to provide those assurances. We should not assume that this man, who at this point is innocent until proven guilty, is a danger to the community because of this isolated incident. He has no history of violence. There's nothing in his past. He was here on scholarship. There's nothing in his past to indicate he's a threat to the community, and we should not just assume because of this incident where he was attacked. I understand there are very many heavy hearts in this room, and a lot of people think he is guilty. They're entitled to those opinions, but at this point he is innocent until proven guilty. There's nothing in his past to indicate that he's a threat to the community, and it is not fair to assume that he is going to try to intimidate, frankly, when he is very much outnumbered as he was that night, or that he's going to flee when he does very much want to clear his name.
You know, here's the thing. I can envision circumstances under which, I can see Mr. Jones being released. My overarching concern is the safety of the community, because this was such this was just an act that it wasn't like, somebody loses it, snaps, and then takes a baseball bat to a windshield. Something along this is actually the loss of life and the near loss of life for 3 of the young men. And so this aspect about the danger that Mr. Jones presents, it's actually the fact that he really has no history and took this action that night that causes me more concern than anything. I can envision circumstances that I could consider, but I don't have them in front of me. I could consider releasing him, in that being real-time GPS monitoring, with urinalysis testing, with the fact that pretrial services, an actual physical officer has the ability to go into the home and search the home and make sure that there are no weapons present. Basically a dusk to dawn curfew on this. I don't know that exists. So I don't think I have enough information and enough concreteness for me to be able to consider that at this time. What I'll do is I'll give you an opportunity to see whether or not that can even be done. But if it can't be done, then I'm going to maintain the bond. And I'm going to maintain the bond today. I'll give you an opportunity to see if that's even possible. And then I'll set up for a hearing again to see whether or not that's done. But if it's not, then I don't think I have enough to give me the assurance that I need for the safety of the community. And I believe that Mr. Jones will come back to trial if he's released. I have nothing to suggest that he won't. This shows me that he is absolutely at the lowest level for flight. And candidly, I have to say, I would probably put my money on this one than I would on the idea that simply because somebody is charged with an offense, that automatically throws them into, they're going to flee to Mexico or parts unknown. But the concern that I have is that Mr. Jones, for whatever reason, without any prior history whatsoever, took the actions that he did on that night. And so at this time, I'm going to deny the motion to modify the conditions of release. But I'm letting everyone know that I will consider that. I'm not saying I'll agree to it. I will consider it, though, if you're able to determine whether or not any of the concerns I have or the conditions that I would consider can even be accomplished.
Your Honor, we'll certainly look into that.
Let me ask for where we are with regard to discovery and disclosure and witness interviews.
No witness interviews have been conducted as of yet. Well, let me say, the state's witness interviews, I believe, are all finished. No defense interviews of those witnesses have been conducted. Disclosure, I believe, is up to date. We discovered yesterday there was a recording that we did not have, and so we've asked for that. But it's substantially complete. We're making a phone call over to DPS Labs today as well to see where they're at with some of the testing. I know serology has been completed on a number of items, and we're looking to see what the timeline is for some DNA testing as well. We'll be sending out some information out to our reconstructionist, and so we'll be getting a report from him as well. So that's, as far as disclosure, that's where we're at.
Mr. Davidson, Mr. McCallum.
Your Honor, I know that last time we were here, we were told that probably the end of February is when we would get that expert's report. I don't know if that's still the timeline. Doesn't sound like it, so obviously we're still waiting for that. I know at one point we had talked about a pared down list of witnesses that we could interview, the state was going to provide us. We don't have that yet. So if Your Honor wants us to get going on interviews, certainly we're eager to do that as well.
Well, within the realm of whatever you can with the disclosure that you have, obviously. I mean,
right. We don't want to get ahead of ourselves.
We did provide a pared down list. I don't know if the defense realizes that. I think it was before the end of the year. I mean, we have a list. It was disclosed. So I'll get with Mr. McGowan again and let him know.
This is, I really think that this is, given the number of witnesses that have been disclosed and the issues in this case, I really think that both the prosecution and the defense need to get together and give me basically a joint Rule 16. I know we don't call it, it's Rule 16 in civil rules of procedure, but a joint scheduling memorandum where I have clearly defined dates that the parties have agreed to where discovery and disclosure will be done, witness interviews completed, expert reports, rebuttal expert reports, interviews of the experts. It's difficult for me to set dates and deadlines that are in fact meaningful and significant if I don't really have a roadmap that's given to me by the attorneys who do know an awful lot more about the case than I do. Can I get that within the next 30 days?
Absolutely.
Yes.
Okay, and then I will set the next CMC based upon the date that I have by the next date that I think a significant event should take place, either close of discovery, the disclosure of the prosecution's expert report. That might be an issue. I just don't know I don't know how this is going to proceed because I don't know what the parties anticipate in terms of the discovery and disclosure process.
I understand, Judge. We'll get together and figure that out. Thank you.
Mr. McCowan, Mr. Davidson, anything further? No. Mr. Shea, Mr. Barker, anything further?
Nothing further. Thank you.
Right. Gentlemen, thank you for all your hard work.
Thank you.
Ladies and gentlemen, please stay in the courtroom.